comments just led me to another spontaneous question that I came up, and I've been asked this before. In small claims, does the idea of the stare decisis, which is the idea of precedent, does that apply in small claims as well? I mean, the reason why I'm asking is because people are so scared about having to do legal research and apply legal reasoning to their story. And this is really what we went to law school for. It's very difficult to understand case law. Do you have to bring in case law to small claims?
Oh, gee. I usually expect it from representatives.
I see.
I don't usually expect it from self-represented litigants.
Okay.
But see, that is tied to the fact that you might not get your decision on the day. Because I will say to the people, you've raised an interesting issue.
Okay.
I know there is case law on this issue.
Mm-hmm.
I know that the case law has gone two directions. So I'd like to check it before I give you a decision, right? And I will look up the cases.
Oh, so
and check the case law. Yeah.
Do you have a law clerk, or do you have law clerks assisting? I know that in the regular court, the Supreme Court, they have the law clerks doing this, right?
At trial, we have a court monitor, but we don't have anybody to assist us to do research or writing. No.
Oh, okay.
We do our own. And usually, the issues in a small claims trial are fairly clear-cut. There's the odd one that raises really novel or different issues. I think I've had one, maybe two. But I can tell you on the subject of whether you're stare decisis or whether you're bound by case law from above.
Mm-hmm.
Almost the hardest part of small claims judging is that we're bound by everything from above, even if it's inconsistent. Right?
Oh,
So we have to pick which line fits better, right? If there are two lines of cases on a particular issue, we have to find which line fits better so that we can give a sensible judgment that isn't negated by because we're bound by everything. Everything above me binds me, right? The only time I had one that really opened up some new areas, it was someone suing for breach of privacy, right? And since there was nothing as yet, I just wrote my own. Right. I wrote, I just set out what I thought were the requirements for a tort.
Right, but it's so good to know, because I've heard some people, including lawyers, who complain to me saying that small claims court is not very principled. Like they tend to give me the impression that small claims judges just decide on a whim, or they decide using a lot of discretion. But now you're telling me that actually it's really not that different from regular court, in a sense that because you still have the stare decisis working to provide some sort of certainty, I guess, some sort of predictability. I know that's kind of I almost want to take back my words immediately as I say them, because I know that even though we think that this is supposed to provide predictability, it really doesn't. But yeah, it's actually very reassuring to me that you would. So if a self-represented litigant comes to court and they don't know that there's case law, but you do, then you will take the time to look it up to make sure that it's a fair decision based on principles.
Yes, I think the people you are talking to might have been to small claims sort of 10 or 15, maybe a few more years ago.
Oh, okay, right? Possibly, yes.
As the jurisdiction has risen, right? As it's involved more and more money. To my understanding, certainly in my case, but I think in most people's cases, the deputy judges have buckled down. We used to run our own continuing education. Now it is done by Deputy Judges Council. So we have a seminar every year on important appeal cases, on how to look at various types of cases, the things we can consider. Because for example, we do a lot of home renovation cases. So we had a paper and a presentation on home renovation cases, the type of evidence you should be looking for, what would constitute good, that sort of thing. So there's a day-long seminar every year for all the deputy judges so that we get training.
Wow.
So as the monetary jurisdiction has risen, the job has become more and more serious about making sure that the underpinnings of what you're saying are sound, right? The other thing is that the divisional court, of course, is available to hear appeals from small claims court decisions. And if our reasons aren't sufficient, or if our reasons are not logical, if they don't support the result, then they'll be overturned. But particularly, right, sufficiency of reasons is important because the appeal court has to be able to say, yes, this is how the judge came to the decision. If they can't say that from the reasons, they'll overturn it.